You hear me? Hello.
Yes, hello, mic test. ये लिखिए sir. Mic test 1 2 3 4 mic test.
Hello.
All mic चालू.
Hello. Can you hear me? Can you hear me, please? Can you hear me?
Yes, हमारा mic चालू.
Hi. I can't hear you guys. Hi. Can you hear me?
Is that Karthik?
Yeah, I can hear you guys, but I'm hearing you very faintly. Yeah.
Yeah, I think because there is some background music going on. Okay, maybe that's the reason.
Okay. Otherwise, we're good, right? You can hear me?
Yeah, we can hear you.
Okay. Okay. Great. I can't see you guys yet, by the way. Huh?
Yeah.
Now?
I can't see you guys yet. No.
Neither I can see anything.
Oh, okay. So you guys are seeing like this link called going live in.
Yeah,
That's
yes,
fine.
that's
That's absolutely fine. In 4.5 minutes, all the screens will merge. It's their
Okay.
software.
Okay. Okay. Understood.
Yeah.
Okay.
But I think, Michael, everything is okay, right? Yeah, it's all perfect, guys.
Okay. Cool. We'll go back to cramming then.
Yeah. So these two can be carpet.
Do not disturb वाला लगा दो.
Yeah, please.
We are all gathered today at AAA-ICDR's Asia headquarters for our event, India-US Transactions and Disputes. What can possibly go wrong? A warm welcome to the in-person attendees who are here with us this evening in Singapore, and greetings to all of you who have joined us virtually from around the world. Before we begin, I would like to invite Michael Lee, our Vice President and Head of Asia, to share a few words to kickstart the event with his charismatic personality. Side note, he pays me to say all of this.
Thank you, Asta. I'm not sure about charisma, but I do have a very delightful personality. And I actually look even better in person. So I look forward to meeting you in person very, very soon. For those of you who are here today with us, we do have some cheese and wine. And wherever you may be listening in from, here at least in Singapore it's 6 p.m. So it's okay to pour yourself a glass of wine. Asta and the team, the panel worked really hard on this. So please rest, relax, and kick back and enjoy the event. Welcome to Asia Case Management Center. Thanks, Asta.
Thank you, Michael. I'm Asta, Director AAA-ICDR, Asia Case Management Center. Although AAA-ICDR has done this several times for me, it's the first. Little nervous, but excited. To make it better for me, I'm joined by a stellar panel of speakers who need no introduction. We have Karthik Maheshwari, partner in the corporate. Next up, we have Karthike Mahajan, partner with Khaitan and Company's Dispute Resolution Practice Group in Singapore. He is a triple qualified lawyer in India, England and Wales, and the state of New York. His practice focuses on international commercial and investment treaty arbitration, commercial litigation with a cross-border element, and enforcement of arbitral awards and court judgments. Last but not the least, we have Renuka Shastri. She heads the legal department of Reliance Retail Group of Companies on various matters, including cross-border transactions, trade regulations, and provides regulatory advisory with an understanding of technology, product development, and cloud computing. Welcome all our panelists. With that, we end the introductions and deep dive into the topic of discussion today, beginning with transactions. Karthike, my first question is posed to you. You've acted as a key counsel in various cross-border transactions. In your past experience, which sector has received the maximum foreign investment, specifically from US entities? In India, do you see any change in this trend?
I mean, so far I've been in practice about 18 years odd now, 17 years odd, and I think really, if I had to say that, look, what's number one, two, three, four between US and India, I'd definitely put life sciences, healthcare right on top. I think right after that I'd put IT services, and then of course you've got this whole new consumer internet story, etc. That would come as a number four on my list. So really, those are the one, two, three, four: healthcare, actually, life sciences around that, IT services, and now consumer internet, consumer companies. And I mean, let's just look at the numbers, right? If you look at consumer internet in India and retail trading, online retail trading, for example, I mean, if you just look at number one, two right now, I mean, some could dispute the numbers, but really, in terms of eyeballs, you have a Flipkart up there, you have an Amazon up there, and both, surprise, surprise, are US entities operating in India. So that really gives you an indication of how large the US companies are here, and how large this whole this interdependent ecosystem between India and the US is getting in this market. If I look for something which was has potential to get larger, perhaps not so far. It's been manufacturing. I think U.S. manufacturing. India has been it's been there, but it's obviously not been as large as the other sectors they've been invested in, or where you've seen the eyeballs. For me, that's one sector to watch out for, where I see a lot more participation from North America into India.
And now that we are seeing a slump in the US market and the recession is making headlines, do we see any change in this trend in coming years?
I don't. I think Asta does not jump to recession. I think that's one word we're all scared of. So no recession yet. I think maybe slowdown. That's a better way to call it. But I think the sectors I spoke about, they're here to stay. I think life sciences, healthcare, a bit more on financial services, IT services. I think consumer internet. I think they're all here to stay. I mean, the potential in India as a market is so large. I mean, and it's the market is just growing with with data prices going down, mobile phone penetration going up. A new segment of customers who are coming into the consumer economy. I just think that pie is getting larger and larger. So I mean, to me personally, I think these 4 5 sectors, they're here to stay. I think as a firm we see continued interest there.
And when we enter into these large transactions between India and US entities, again, my question is again to Karthik, since you have been working on really large transactions involving US entities. So, what are the common areas of disagreements between Indian and US parties? Are there a lot of disagreements, or do we see smooth transactions?
Honestly, I wouldn't call it disagreements. I would call them slightly, more, just more aspects of India deal making. I don't think U.S. companies expect that negotiations can go on so long, or sometimes negotiations can get a little bit more tense. The negotiations tend to stretch out a little bit more in India. So I think that's one piece which people have to sort of bear in mind, be a bit patient about that. Look, deal making will not happen overnight. Even if you have an agreed term sheet, by the time you come to your definitive documents, you come to your larger commercial discussions, there will be points where there will be pushback, where maybe what you thought was agreed is not fully agreed. It'll be opened up. So I think that's one point where I think business from both sides should appreciate that. Look, things are not going to happen overnight. You've got to keep some space for give each other flexibility and negotiate this out. So that's one point where I think it's not just going to get done because you have a term sheet. Just be ready for negotiations on even aspects where you think matters have settled. I think the other one is U.S. investors. I mean, it's more typical U.S. style. It's very binary. It's either yes or no. There's I think what you see in India is okay. Let me think about it. Why don't I talk to my senior management? Why don't I talk to my family members? Why don't I talk to others in the business? It's a fair point, but maybe let's find a middle ground, a more nuanced position. I think sometimes on the U.S. business side, it can be a bit binary. I'm not saying it's always the case. People always want to find this own level, and people always find a solution when there's larger commercial interests at play. But just a little bit more back channeling in India, where on negotiations, etc., where you may not get a straight yes no on the email, or you may not get a straight yes no, in front of a 15 people negotiating table, where people will simply say, look, why don't we think about this? Why don't we take this offline? Why don't we just give it a little bit more thought? Why don't we consult a few others? So I think that's one more, just I wouldn't say cultural issue, but it's just a bit of a nuance when it comes to the art of the deal here. And I think I mean in terms of common areas of disagreement, I don't really think there are any common areas of disagreement. It's the same the world over. Some things like valuation. What's your addressable market? How do you reach your valuation metrics? What really is our combined strategy? Who gets how much control? Who gets to consolidate the JV? Who doesn't get to consolidate the JV? I mean, these are the standard things you would see anywhere in a joint venture. It's not India specific. So I mean, I won't say it's like you will not see I mean, like any other part of the world, you will see these issues coming up in India as well. I know Renuka does a lot of these joint ventures and other arrangements. Renuka, do you agree with me on that? I mean, no, really India specific disagreements, right?
I do agree, but I think it's not the disagreement. It's the mindset of trying to solve, and it's also the mindset and what is it that we are signing off, right? Being an Indian party or being a US entity, it's how the evaluation goes into what's the risk that we are signing off. Mostly, the Indian entities or the Indian partners they want to be compliant, and they are looking at the regulations which are applicable because they're close to it. And also the regulatory regime is changing very, very drastically, right? So that's something that the US entities or the foreign entities are also concerned about as to what will be the future. And we are seeing a lot of regulatory changes happening. So I think that's the area where that's subject to negotiation, that's subject to discussion, and also the sidebars normally that happens during the transaction discussions. So I think that's where it is.
Now, coming to my favorite area, and this is my personal favorite considering I am working in the arbitration space, is the dispute resolution clause something contentious? Do the parties usually agree on the dispute resolution clause, or are there some disagreements there?
I think one mistake people make on this dispute resolution, I think, is I mean, call it a midnight clause, call it a boilerplate clause. People just don't give it the importance, and then at some point, in a discussion, if they haven't focused on it earlier, it sort of becomes a larger issue to solve for. And just to give you a practical example, I mean, I see a lot of US contracts where folks simply just write, subject to dispute resolution of US state courts, subject to, federal court or SDNY, etc., where people have used their standard form contracts and then they're trying to apply that to this, this Indian deal they're trying to do. And honestly, it just doesn't work. By the time people notice that, look, this is in the document, or oops, you haven't focused on it so far, it becomes a problem. None of these it's very, very difficult to enforce a US court judgment in India, whether it's state court or it's federal court. There's no reciprocity of the judgment, so literally you got to start that process from scratch in India. You get the judgment to India, and then you start the entire suit proceedings here, etc. Versus arbitration, which Karthik will talk about, which is a much, much easier process of getting an arbitral award and enforcing it in India. So I think that's one very common mistake we make, where people say, look, this is how we do it. We like all our contracts on the US coast or state or federal courts, and then you got to tell them, guys, this doesn't work here. It may be a standard process, but your standard process will bite you on the India deal. I think in terms of a move to an arbitration, Indian clients, I think they're being more practical now. No one really says no to an arbitration clause from now. I mean, they know that given what's at stake, and the international counterparty involved, the US party it'll be much better to give them the comfort of arbitration. So I don't think that's really a gating item in terms of should we go to Indian courts or should we go to arbitration. I think there's a lot of maturity along the way, and people have learned to be reasonable on that point. What I would say is that Indian parties do get a bit perturbed. They don't like seeing, let's say, a Geneva or a Paris venue of arbitration. They know it can really blow up costs. They don't even like a UK or a London-seated arbitration these days. They prefer bringing it closer to home, whether it's Bombay or a Singapore. That's one point. And the second thing is, when dealing with the US party, I don't. I think most Indian clients I know, especially the most sophisticated ones, they are very, very conscious and aware of discovery. They don't want the risk of discovery coming back to bite them. They don't know how the discovery procedures can work. They think discovery has a process of just escalating costs. Discovery can really upset business as usual, etc. So they don't like that concept at all, and they would rather stay away from it. And they know arbitrations sort of a safe way to get outside this whole boundaries of of a US law discovery process. Sorry, Karthik, over to you on this one.
Yeah, sure. Happy to, Karthik. I think you really touched upon some important considerations when it comes to determining a seat. I think you're absolutely spot on that arbitration is the go-to way of resolving disputes. And I think the primary reason for that is the New York Convention, because New York Convention is possibly the only global treaty which has so many signatories. And in modern day, I don't think you will find that many countries to agree to any treaty. And that's why I say the court convention has not been ratified by enough number of countries, which is a clear evidence that what happened in the past with arbitration, by which you have an award, you get it enforced under New York Convention in 196 countries across the globe, is just practically not going to happen again. And if it does, it's going to take a long time. And what does that mean? It means that court judgments do not have the same sanctity as what an arbitration award has. And that's what all cross-border transactions end up encompassing in the dispute resolution clause. Now, whether be it India seated, Singapore seated, New York seated, London seated, all of them will be covered under New York Convention. But when it comes to choosing a seat, and I think that becomes a crucial thing when it comes to dealing with cross-border transactions in India, uh, Singapore clearly seems to be the preference. Singapore seems to have a little bit of edge over the others. Maybe it's the first movers advantage in which a lot of institutions from Singapore, like SIAC, AAA, ICDR, started advocating towards Indian parties promoting Singapore as a seat. But the real fruit started bearing when Indian parties and other cross border parties started realizing 3 to 4 factors which are associated with Singapore, which works in its favor. First is a robust court system. You can get a judgment from a Singapore court within 1.5 to 2 years. You can get a setting aside decided ultimately, and most often than not, setting aside would be refused. It's very rare that setting aside applications are successful in Singapore. What does it mean? That they are extremely pro arbitration. And that also, which is my second factor, is also applicable when they are interpreting an arbitration agreement or a dispute resolution clause. As long as there is a stray reference of arbitration, Singapore courts are willing to uphold the arbitration clause and say that the matter should be referred to arbitration. And I have personally experienced that, in which there have been certain pathological clauses that I have dealt with, in which, say, Singapore International Arbitration Center has not been defined properly. What has been given is Singapore Center under the dispute resolution clause, but a Singapore court has said that, listen, nothing doing. There is a clear intention of the parties to go for arbitration. That's why we will say that let's go and knock it out before the Singapore International Arbitration Center and don't come before us. The third point is that when it comes to, say, even an American party, I think they are absolutely familiar with having arbitration in Singapore. And this is also witnessed by the fact that US is actually the second or the third largest user of SIAC cases in their annual caseload. And this is a fact which is not as advocated, because in this part of the world, people keep on talking about India and China. While they might be the two highest users, US is close to China, and in certain years, it has actually trumped China in terms of being a user of SIAC. And the fourth thing is that there is a sense of familiarity for US businesses in India, in Singapore as well. You look at a lot of US corporations, their regional Asia Pac headquarters are situated in Singapore. They're familiar with how Singapore works. They have been in this region long enough to know how Singapore courts are. And that's why they're also pushing for Singapore as a seat. So while all these factors work towards Singapore, I'm just going back to the point of what Karthik said, which is choosing, say, a seat in India. I think increasingly US corporations having Indian subsidiaries are also very familiar with having India as the seat. What they are going for is an institutional arbitration which is seated in India, and there are practical advantages to it, because under the Indian Arbitration Act, you have a time bound manner of resolving disputes. You actually have to conclude the arbitration between 12 to 18 months, depending on if you get an extension after 12 months and if you have reasons to ask for an extension. But this is possibly the only statute in the world, or any statute in a arbitration friendly jurisdiction in the world, which actually imposes a timeline to finish your disputes. So many people are seeing the advantages of having arbitration in India, and they're opting for it. And when it comes to New York, just again alluding to what Karthik said, which is regarding discovery. So when it comes to US courts, there is an expansive discovery. You can have very broad discovery requests, something which is very unfamiliar to arbitration users who are accustomed to red fern schedules, in which the discovery has to be very narrow, pointed, you know, asking what is really relevant and material to the case. Whereas if you go before a US court, discovery can be really expansive and broad. Second, in US courts, you also have the option of taking discovery against third parties. For example, banks. If there are certain transactions which have transpired through Bank of America, there is a provision under the US statute called 1782, which used to basically permit you to go to a US court, ask for discovery from these third parties to aid in arbitration. Now, recently there has been a change, because the US Supreme Court has come and said that for commercial arbitrations, you don't have the provision of 1782. And in fact, 2 weeks back, there has been a decision which says that even for investment treaty arbitrations under ICSID, you don't have 1782. But if you have a New York seated arbitration, I think the chances are that the US court will allow that expansive discovery. So that's why discovery itself is a huge deterrent to go before New York or any other US city as a seat of arbitration.
Thank you very much, Kartikeya. Since you touched upon pathological clauses, that spikes my interest from an institution's perspective, because when we see a pathological clause, we don't want to touch it. And before reaching to the arbitration, the parties have to go through court processes, and it in turn lengthens the entire dispute resolution process. So, from that perspective, what tips would you give to parties drafting a dispute resolution clause?
Sure. Uh, See, I think there are a number of considerations that parties should bear in mind. I'll just say the top four that come to my mind. The first is that there is an increasing adoption of multi-layered clauses in contracts. Parties end up asking for mediation, followed by reference to arbitration, etc. When you have such a thing, you have to be very clear with respect to your timelines as to when the first step gets invoked, then the second step will get invoked, and then finally it'll be arbitration. Right? Say, example, a dispute arises, a party notifies within 10 days of that, and then the negotiation has to conclude within 15 days of invocation. After, if 15, after invocation, within 15 days, if you don't have a result, then go and try and settle the dispute before SIMC mediation. But again, you have 15 days, and then another 1 month goes, and if there is no result, then go before arbitration. But you need to specify all these things. Also specify institutions for mediation. I think it helps cut costs, it helps ensure there is no dilatory correspondence on that issue. So always have very clearly well drafted arbitration clauses or dispute resolution clauses, and ensure that your dispute resolution lawyers within the firm are vetting them. I think it's very important, because some, vagaries that Indian courts have dealt with, which is the differentiation between venue and the seat, and there is still so much of satellite litigation on it. I think it's very important that you get it right in the clause itself. You should specify what is venue, what is seat. The last thing that you want is being hauled up before an Indian court, litigating unnecessarily, spending time and cost deciding these prelim issues, which could have been just resolved had a dispute resolution lawyer looked into it. Then the third thing is that I have seen that people don't realize what exclusive jurisdiction of a court is, and you will still end up seeing some agreements in which exclusive jurisdiction clauses are there along with arbitration clauses. Now, that is kind of really odd, because if, say, you have an arbitration clause which says that the seat is in London, and then you have exclusive jurisdiction before Indian courts, it just leads to a lot of confusion. What will happen eventually is that if the seat is in London, an Indian party or any other party, in order to defeat the arbitration clause, will start proceedings in an Indian court, and it can be any court on the anywhere in the world, depending on where the exclusive jurisdiction has been conferred, saying that, listen, this court has jurisdiction, that's why arbitration should not be invoked. Whereas in reality, for any pro arbitration jurisdiction, the court will say that, listen, there is a clear intent of arbitrating, that's why we will not interfere. A Singapore court will do that. So that's why let's avoid this kind of satellite litigation as well. I hope I've answered some. Maybe Karthik, do you want to throw some light from your
Yeah,
experience?
yeah. I'd say a few more items. I think, watch out in the dispute resolution clause. I mean, so many times a client will tell you guys, make it a sole arbitrator. Having three arbitrators, one by the claimant, by one respondent, one by, if you can't decide, then mutually, then obviously the institution will appoint one. So many times they tell me, guys, why are we not making it a simple sole arbitrator? It's going to save us time, it'll save us cost, it'll save us scheduling efficiency. I think it's I mean, that's really my personal view. I know the jury is out there, but I prefer a three-member arbitral tribunal. It gives you more diversity. If someone's being stubborn or uh, just more expertise also on the panel to come to a conclusion. So really, that's something to think about. I don't think cost and efficiency is the only criteria there when you're choosing is whether it should be one arbitrator or three arbitrators. I think got to look at the bigger picture as to if it's a complex matter, and there are going to be some complex facts out there. You really have the right set of people applying the minds, and really maybe three is better than one. So that's one item I would say that people really need to think about when you just put that arbitral clause there, sole arbitrator or versus a panel. Then obviously if it's a low value dispute, low value contract, then perhaps sole arbitrator is the way to go. But I think the other one I would talk about is just in Indian contracts. There's just, especially if there's a foreign seated or foreign venue arbitration, you have a Singapore arbitral venue or a London arbitral venue. Regardless of rules, you'll have one blanket clause in the agreement which says, by the way, parties hereby exclude the application of Section 9 of the Indian Arbitration Act to this particular dispute. Now, the problem with that is that means neither party can go to an Indian court for interim relief. And I mean, yes, what you're trying to solve for? You're trying to solve for some kind of anti-suit injunction. You're trying to solve for some kind of needless interference by Indian courts, which frankly is a bit rare these days. That's one. And I think more importantly, again, is are you going to shoot yourself in the foot by asking for those clauses? I mean, for example, if I was a US party, I had a non-compete on my Indian counterparty. Really, I mean, what do I gain by saying that, look, I will not go to an Indian court for interim relief for the non-compete? Am I then going to go through this whole this circle of first going to a US arbitral tribunal, trying to get an emergency award, get the emergency award to India, and then put it into execution? Am I not better off simply saying, let me go to Bombay High Court or Delhi High Court and try to enforce my non-compete? Similarly, let's say if I was an Indian counterparty, uh, let's say I need the benefit of an interim relief for whatever reason it could be. I mean, let's say something as basic in the document as, let's say, confidentiality. The deal is not happening. I want to preserve my confidentiality. Why would I go through this whole rigmarole of going to a US arbitral tribunal first, trying to get an emergency order from there, and then getting it to India for execution? Am I not better off simply by approaching a high court in India for saying, look, guys, our arbitration is pending. You don't have to comment on the facts of the arbitration or the larger merits, but I just need some protection for confidentiality in the interim period. So I think it works for both parties. Maybe one solution is a little bit more elegant drafting where people can say, look, if there's a dispute which relates to the non-compete or non-solicit clause, in that case, there's no waiver of Section 9. Parties can come for interim relief to India. Similarly, if you have something which talks about confidentiality, you can have some kind of safeguards around that. But I just think this whole piece around just a blanket statement saying Section 9 excluded in full, I just think it's not the best market practice. I think people need to think a little bit about it. Just two more points for me. I think another overlooked point is when you have a large transaction, it's a joint venture. Joint venture's got a JV agreement, shareholders agreement. It's got, let's say, some financing agreement. It's got a license, a brand license, a franchise, a technical service, everything thrown in. I think it's important for parties to then consider, guys, do we really need to call out in each document separately that, look, there should be a consolidation of the arbitration if there's a dispute. Otherwise, the problem is you have so many parallel proceedings going on. One answer to that is some of the institutional rules do clearly say that, look, it is the arbitrator's discretion to say if he wants to consolidate any particular, any cross disputes, etc. But the point there really is, I mean, at that point of time, it's open to a party to object to say, look, I will not get a fair hearing. That was not the intent. This is not, each claim should be treated on its own merits by a separate tribunal, etc. I think some thought should go in there, especially if you want to keep the process efficient and streamlined, just going forward as well. On how do you really make the consolidation of arbitration proceedings work? Should you get an upfront consent from parties, or should you say, as long as it's just and reasonable, each party hereby agrees that different disputes can be consolidated in the same proceedings? And again, that also goes back to the time of the transaction. Do all the transaction documents have the same governing law? Do all the transaction documents have the same dispute resolution provision? So those are things to think about. But I do think on a more complex transaction where there are many moving parts, a party should strongly consider consolidation. Really, I mean, they've come to arbitration for efficiency, for time, cost, and other reasons. So get that efficiency by considering a consolidation clause upfront. Sorry, just for everyone's benefit, if I didn't explain it earlier, consolidation or clause is like a clubbing proceeding where you ask the first arbitrator to sort of club all the different disputes into one arbitration instead of allowing multiple arbitrations to proceed. I think my last one is I know it's going to be not everybody will agree on this. Most institutional arbitral rules have a loser pays clause that the loser must pick up the entire cost. But I mean, really, is that always required for every circumstance? I mean, for example, let's say you have a purchase price adjustment, you have a net debt calculation, you have a net working capital calculation, which affects purchase price. I think it's in the if parties have not agreed, the experts, they don't agree with what the expert has done there in terms of calculations, and they want to arbitrate it. I'm really not sure if you need to have a loser pays. I think maybe that's something which requires a little bit more balance by saying, guys, look, this is both our interest to come to a fair number which is accurate and which has been properly agreed upon. Maybe something like that should not be loser pays. Maybe something like that should be 50-50 of arbitral costs. I mean, just a thought. I know that the incentive of loser pays is that nobody should really be getting frivolous claims and wasting each other's time on litigation when you can resolve it yourself. But just another thought on look, I mean, it doesn't have to be loser pays always. Maybe when you're putting your agreement together, parties should think that, look, if certain aspects go to arbitration, maybe it should be 50-50. It shouldn't always be loser pays. Sorry, I've taken up a bit more time on this one. Back to you, Renika.
Coming to Renuka, that usually, so there are lawyers and then there are parties. From a party's perspective, what are the key points? Is cost really a big issue that the parties keep in mind while settling a dispute resolution clause, or it's not something that parties stress upon? Dispute resolution clause is something that only lawyers are settling these days.
I think I'll give you the way I have kind of attended to this particular issue. Especially, I take it as disputes, the possible disputes that normally may come up in the future because of out of the transaction. The way that I have always taken the approach is I have bifurcated the commercial related risk, categorized the risk which is supposed to be subjected to the arbitration, and something that both the parties can come together and then resolve it. So that's how the bucketization goes on from my end, at least, to both the parties to say that, does this have to go to the dispute resolution mechanism, or is this something that the both parties will have to come together and then resolve it? So there is, basis the bucketization and bifurcation, there are certain risks which are subject to mutual discussion, curation period, and that's how, at least, I've taken an approach to solve it without much complication, but something that is a question to the very transaction, the question to the very objective of the deal or the transaction, be it commercial or the JV, like how Karthik was referring to. I think that's something that should go for arbitration. So that's the approach that I have taken, where both the parties have been brought to the table and asked, what is it that you intend to, or what is the mindset or the um, kind of objective that you are coming to the table. So do you want a long term relationship going, and how do you want to solve it? So majority of the times both the parties do agree, saying that, whatever that can be resolved with mutual discussion and mutual kind of resolution mechanism, that can be resolved. But yes, the very objective comes to the question, then that's subjected to the arbitration.
Very, very interesting and helpful tips that we have received today, and our viewers will definitely be using this in future. Since we are short on time, I'll quickly touch upon a small yet very important aspect, because parties are, especially foreign entities these days, are having reluctance in entering Indian market because of the regulatory issues that they are facing, the tedious compliances. So, what are the different types of compliances that a foreign entity has to go through, and is the reluctance actual, or despite such tedious compliances, U.S. parties in specific are still entering Indian market, since it is one of the largest markets? So this question is to the panelists. I think Karthik or anyone would like to take this up.
I'll pick it up, and then obviously Renuka should chime in. And my point here is that, look, I mean, yes, I mean, regulatory compliance in India can be hard, especially manufacturing businesses. There's a lot more to, there's always something to look out for. But my point here is, and it obviously gets complicated because there's no concept in most industries of a single window clearance. You can't just go to one person and say, hey, give me all my tax registrations, give me all my labor registrations, give me all my manufacturing, hazardous waste handling, environmental approvals. I mean, the single window piece is a bit of a myth. You've got to do your running around. It adds to regulatory time and obviously, some amount of efficiency as well. But I don't think any of that sort of has spurred up investors. I think it's sort of factored into the cost of doing business in India in terms of, yes, there will be some regulatory overhang, there will be things to watch out for, but the market's big, the rewards are high. I mean, the risk of regulatory non-compliance can be mitigated through good effective practices. Having the right team, outsourcing where and what you can to experts. So I don't think just the regulatory compliance piece is a barrier to entry in India. That's really my view on this one. Renuka, back to you.
Thanks. I think regulatory requirements is not anymore a blockage for anyone to enter into India, because um, what we, at least I have observed, is the regulatory departments are open to understand, open to take feedback, open to kind of take inputs from the industry players or the market players. And also it's the requirement which is making the industries compliant, and which is setting the high bar to be met. I think that's not regulatory compliances are never considered as something that can work as a mindset block to enter into India market. I don't think that's an issue. Yeah, there are what I have seen is um, the investors or the foreign entities think that there is ambiguity and there might be gray areas, but I think it's how it is evaluated, and what are the risk that is really kind of assessed. It really depends, and the industry into which the foreign entity wants to make an entry is also something more relevant, and there needs to be some homework that is supposed to be done for that.
Yeah. No, thanks, Renuka. Just one more point for me. I think it's really a regulatory arbitrage point. I think, for example, something like corporate governance in India, for let's say private companies, it's actually much higher than the US. For example, there is annual disclosure of financial statements. Which is publicly available in the register of companies. That's something which is like you don't see that concept in the US. There's annual disclosure of beneficial owners in India. You again don't see that really in most US jurisdictions. And I think the third piece, I mean, a lot of US clients ask me this all the time, is that it is mandatory to have a statutory auditor in India for each company and to have audited financial statements at the end of each year. And that concept is just not there for a US private company. I mean, they do complain that look, this is just increasing regulatory burden and compliance. But I think at the same time, it does, give you it's much more in terms of transparency. It's much better from a stakeholder perspective. The customers, vendors, etc. They're much better informed. They can make informed choices when working with a company. So I wouldn't say it is a surprise to U.S. investors with respect to the level of disclosure in India for private businesses, but I wouldn't necessarily call it a bad thing.
Mhm. Now, my next question is again coming from regulatory perspective. What, again, to Renuka and Karthik, what are the different entry routes that foreign investors are taking to enter Indian market, and what is the most preferred in your experience?
I think most preferred, it really depends on the kind of market that the entry is required, right? Because there are regulatory caps for specific sectors that are there, and also, the relevancy to the Indian customers and Indian consumers is something that's more relevant. So if it is a manufacturing concern, it's more of regulatory, related compliances and regulatory related sectors that are relevant. But if you want to enter into consumer market, then that's something that you will have to, you may want to establish your brand, and then you want to expand your businesses across India. So it's mostly the relevancy, and how do you want to make it relevant in India. So that's the relevancy part that's more critical, Asta. That's how I look at it. So there are branches that can be set up. There are uh, JVs, there are franchisees, licensees agreements, and so many other different mechanisms that can be taken as an approach, which has been the trend in the market as well. But it really depends which sector there is an entry that is required to.
No,
So,
Renuka, I hear you. I think something like manufacturing, something like services, IT services, etc. People tend to prefer having their own wholly owned subsidiaries.
Yeah.
Things like where they want to really rely on a partner. You'll see more franchise arrangements or licensing
So,
arrangements, or even joint ventures because you want to take advantage of your partner's strength or your partner's distribution, ability to get better terms with landlords, etc. Whatever you call it. I really think depends on what industry, and it's already horses for courses.
yes, yes.
that the entry route is industry specific, but generally speaking, what all considerations should a foreign entity keep in mind while entering into Indian market?
No, I think one is on due diligence. I think they need to be a little bit more patient compared to what they see in the US and India. I mean, for example, in India, land records are not fully digitized. They have to do a lot of manual searches. So if they're setting up a factory or they're setting up a large warehousing or distribution center or logistics center, they'll have to do a fair amount of due diligence to make sure title is clean. Unlike the US, the system of litigation searches is not very clean in India. For example, a lot of courts are not digitized, especially on the criminal side. There's not a lot of digitization of court records. So you have to do a slightly more painful litigation search process, which requires people to be patient. It comes up with irrelevant cases. A case which may have been there 5 or 6 years ago has been disposed of, but the corresponding court data entry is not being updated, etc. And then you suddenly go and tell your partner or your counterparty, hey, what's going on? You have this litigation against you. And the counterparty will tell you, by the way, this was 5 years ago. It's a chapter closed. Why are you even bringing it up now? This leads to distrust. So, but people need to be a bit patient there, because that diligence process in India does take time because of these legacy inefficiencies. I mean, something similar, right? In the US, you will have the UCC liens very clearly recorded. You know who's got mortgages, charges, liens. In India, when it comes to dealing with a company, it's very, very clear that look, what the company's charges are, security is, collateral is, because all of that have to be registered to be enforceable. But when it comes to an individual, you wouldn't know, the individual's credit history. You would not know the individual's what liens he has against him, what kind of guarantees is given out there. So that again, that's more of a diligence process there. And these kind of aspects you don't really have to consider in the US. It's much more transparent. But look, like I said, it's just a question of being patient and just doing it the right way and carefully, because ultimately it's your diligence, and it can get you results. And in terms of entry routes, I mean, India is quite flexible that way. You can come in through a LLC or a LLP. I mean, if you're just testing the waters, you want to see what the market is, you can do a branch or liaison office. Depends again on what you're looking to get out of your investment into India. But the most common vehicles in the US are either an LLP or an LLC. I'm just seeing LLP getting a bit more popular these days, especially because I mean, it's comparatively, if I can put it, a bit more compliance light compared to an LLC. You don't have to have your four annual board meetings a year, etc. The paperwork and filings are also comparatively lower than a LLC. So the LLP looks attractive, but in my view, most of the times the decisions between LLP, LLC, or any other structure you're putting in, it usually comes down to tax considerations. What is most tax efficient for me in terms of getting my royalty payments, getting my license fees, getting my dividends, etc., or my capital gains at the right point of time. So yes, people like the arbitrage which comes from, let's say, an LLP versus an LLC, but I'd say 90% of the time the decision really comes down to where am I saving my tax dollars.
We have an interesting question. What is their option on Biden coming an obstacle for free trade agreement with
I,
India?
I, think, I think that's a very, very tough question. I'm going to hand it over to Karthik.
I mean, the US India free trade agreement is going to take some time, right? Like, there's not even a clear dialogue which is happening. I think if we are able to execute the India UK free trade agreement, I think that itself will be a big milestone in the next 2 years. So let's hope that happens first. Then we can move on to India US.
But Karthik, coming back to what you said previously with the court processes, I think you have given a spot on answer to our viewers of what can possibly go wrong. And now coming to KK, we have seen that the criminal laws are stringent, and there are certain regulatory laws as well, especially IT laws, which have criminal liability. Considering that, US parties, is there a reluctance again that they might be entangled into some criminal liability if they enter into Indian market, and especially when we come to social media companies and IT companies, and there are many US based entities which are operating in India.
Yeah. No, thanks, Asta. I think it's a very relevant question given what has transpired in the last few years when it comes to these social media companies operating in India. But I think even before that, I think generally what we have seen historically with a lot of our clients who have nominee directors sitting on Indian companies, they've always been concerned about being faced with some sort of a criminal action. And the reason for that is very simple. In India, the criminal laws and various other legislations which just impose criminal liability in some form or the other on the company as well as on the individual are just scattered. And you may end up seeing some ancient legislation which will have some sort of a criminal liability, and you will see people misusing it by not only filing cases against the company for civil liability, but also filing criminal cases against individual directors. And that is just used as a common pressure tactic in India, and it has become rampant in the last decade or so. What it has led to is unnecessary prosecution by regulatory agencies, any sort of regulatory agencies, whether be it the IT tribunal, whether be it or the CBI, whether be it Enforcement Directorate, uh, and a lot of harassment, right? Because it's not only physical harassment, it's also a lot of mental harassment. No one wants proceedings to be commenced against them or being called by the investigative agencies for any sort of interrogation. And that has obviously led to concerns. Whether the government is trying to do something, I think the way to address it is twofold. One is by way of legislative action, and the second is by way of court action. On the legislative front, the government has been very proactive since the time Modi government has come into picture. They have removed a lot of sections on criminal liability. In fact, in the year 2020, if I can recall correctly, I think around about 48 crimes were decriminalized by an amendment in the Companies Act itself. And similarly, a lot of other amendments are being brought about across a whole spectrum of legislations to decriminalize. Whether it will decriminalize to the extent that India will be comparable to some of the developed jurisdictions, it's yet to be seen. But there are steps in the right direction. But on the court front, which is the judiciary front, I think this practice has not been clamped down upon. I think courts have not come up with strict instructions telling parties, imposing high costs if they end up engaging in these sort of tactics to just pressurize the individual directors. And I think a lot of movement needs to happen. The courts need to become aware that this is just hampering business, and they should come up with more proactive judgments which protects these directors.
Thank you very much, Karthikeya. I think we have the answer because I have previously worked in this space and I understand that it is a concern to US parties, but yes, at the same time, the Indian government and the legislature is taking proactive steps to resolve this issue and to make it easier for foreign entities to operate in India. Now, moving to exit strategies. What are the exit strategies that may be followed by foreign investors to probably if to make an exit of their funds, or in case it is a PE funds, what are the different strategies that can be followed? My question can be taken up by either Renuka or Karthik, whoever wants to go first.
So I think I'll pick up with the standard exit strategies or standard exit clauses that we have been seeing, which is the IPO, and one of the other for MSME is also the MSME IPOs. That's also something that we have seen as an exit approach that's been taken. Um, Along with that, the buyback and put option. Of course, there has been a lot of challenges on the put option, but courts have been upholding the put options, right? And also the ROFO options that are there. I think that's the relatively exit solutions for investments or the investors. But like I said, there are different types of transactions, right, and different types of business setups that are there, and that can be adopted, and that really depends as to how you want to exit. And what it actually goes back to the point as to what is it that the entity wanted to establish in India. So was that a support mechanism that they wanted to build, a back-end support mechanism wanted to build in India, like the IT sector, or is it the front end to the consumers, customers? So it all depends on that. So Karthik, I leave it to you.
No, a fair point. I think it really depends on what way the transaction to start with. Did you come in with the mindset of a financial investor that let's go, I'm going to make this business 4 or 5 years and then flip it, or am I here as a strategic partner, or this is a it's a partnership for the future where I grow the pie together with a partner, and as the pie grows, obviously, different parts of my business can benefit from that too. So I really think on exit, it's no one size fits all. But yes, I mean, if I was a financial investor and I wanted a viable exit strategy, I would think of many different ways to safeguard myself, because India is not fully. I mean, it is in many ways freely convertible, the rupee, but in many ways, it is there are exchange control limitations. So that's something, especially from as a U.S. financial investor, I would try to solve for. I think it requires a little bit more careful planning. And look, things like royalty, license fees, dividends, the share sale. There's no restriction in India in terms of repatriating proceeds. There's no prior government approval required. I can take the money in and out as I please. Royalty fees can come out as they wish. Just keep withholding taxes in India. But the bigger challenge comes on things like, let's say, damages. The bigger challenge comes on things like, let's say, if you have, liquidated damages, you have indemnity provisions. How do you get money out of India? How do you repatriate that? How do you structure solutions for that? We'll just talk about it in a little while. And I think even from a structural solution, if you come in India under something called a foreign direct investment route, which 95% of investors from the US use, you are going to have certain other challenges. You can't have a short returns on your investments. You can't do a put price, a put with a absolute minimum guarantee or a minimum IRR. You can only transact your shares at fair market value. But on the other hand, if you use a structure called a FVCI, or foreign venture capital investor, which is a bit of a misnomer, because FVCI is not just for venture capital, it's for 10 identified sectors like infrastructure, IT services, hardware, etc., where you can use this FVCI vehicle. In that particular case, there is a carte blanche exemption from a lot of the exchange control regulations. This piece around put options, pricing, etc., they don't really apply to an FVCI. So that's something to consider. You have the option of using an FVCI, or should you create an FVCI in India to benefit from some of the exemptions available. So I think that's one piece. Just in terms of just initial transaction structure to keep in mind. I think the other piece to keep in mind is, just because are you taking a guarantee from an Indian party? Are you taking an indemnity from the Indian party? If you are, you have very clear drafting in your contract that, look, guys, if a government approval is required for that indemnity proceeds to be paid off, will both of you will act in good faith to get that approval? Usually, that approval is there. You need an approval from the Reserve Bank of India, but they will be a bit shy to give it to you unless you have a crystallized judgment or a crystallized arbitral award with substantiates indemnity. They're not just going to say yes to every single indemnity payment you want. They'll want to see something in terms of a very clean arbitral award which awards that indemnity to start with before you will go for the approval. So those are things to sort of factor for just by writing in your contract that, look, you will pay me XYZ amount of liquidated damages or indemnity, or you give me a guarantee. That just won't be enforceable. You'll have to sort of do a bells and braces approach around that to see that it really syncs up. The law syncs up with what you want in terms of expectations. Sorry, back to you, Asta.
Thank you very much for your expert comments. Actually, we understand and we now know much more about how the foreign entities can strategize as for the exit options. Now, since we have very less time left, I will jump to our last segment of disputes, and KK, I will be taking a lot of your time now. Uh, what are, since we have already spoken about different sectors of US India transactions, what are the different kinds of disputes that are arising out of these US India transactions?
Asta, I think two sectors really jump out. One is private equity, which is basically the exit related dispute, something that Renuka and Karthik alluded to when it comes to exit mechanism. I think a lot of private equity investment has come into India from US as well. And finding ways to exit has always been challenging, especially in a post pandemic world in which the valuations have started depressing, because what you valued when you put in the money is not what you're going to get out now. And the promoter may not have the same kind of money to give you. So that's why it's becoming a challenge, and these disputes are bound to rise in this current macroeconomic climate. The second is pharma. A lot of US companies ended up entering into collaborations with Indian companies to start producing vaccines or other products in India, as a result of which those contracts are leading to disputes. We've seen some of that playing out. Third is, I think, you already mentioned, which are technology related disputes. A lot of social media companies, a lot of, tech companies from US which have operations in India, they are seeing some regulatory actions before Indian courts, not necessarily arbitrations. And they are, I think, again bound to increase because there is going to be stress in the tech sector as well. I think 2 to 3 days back, I think Amazon was complained to, I think, Ministry of Labor or something, because they had laid off, I think, 10,000 people in India. And you know how Indian labor laws are, you cannot just lay it off, and you have to follow certain safeguards. And someone complained to Ministry of Labor. So I think these kind of things, which in a proper capitalist economy like US would not create an issue because the legislative framework which enables that. That's not the same thing which happens in a country like India, which has other demographic constraints because of which the legislations have shaped over a period of time. So you will see this. I think one thing which is not India US specific, but in general I'm seeing a lot in terms of disputes is commodity contracts going wrong. I think a lot of force majeure sort of arguments being taken because of the pandemic, the stress which has resulted because of the pandemic, the supply chain constraints which are still happening right now in today's world because of Russia, Ukraine, and other parts. I think those kind of contracts, predominantly with India, Southeast Asia, India, Latin America, all of that, I think that's also shaping up.
So, from what I gather, that there are a lot of disputes that are arising out of such transactions. But is is arbitration a preferred mode of dispute resolution right now in India? So that courts in India are having a pro arbitration approach, and there is a positive shift. Is arbitration now here to stay? And the second leg of my question, India has seen a lot of ad hoc arbitrations. Institutional arbitrations are still not as much preferred as ad hoc. Is that set to change in near future?
So I think arbitration is the go-to method. I think there is no doubt about it. I think people have less faith in Indian courts. I think they are very comfortable with arbitration. Something again what Karthik alluded to in the beginning of this talk. The question really is that whether it's going to be India seated and or foreign seated, or if it's institutional or ad hoc. Uh, and I think everyone is just comfortable. When it comes to India seated versus foreign seated, I think there is a lot of back and forth about cost or interference in courts, because if it's foreign seated, there's obviously less interference. But having said that, even Indian courts are very arbitration friendly today. You hardly see setting aside, you hardly see refusal of enforcement. We don't have concrete empirical studies in India like what you will have in US. But if someone really puts number to it, you will see very few awards actually get set aside in India or get refused enforcement. I think the latter even scarce than the former. And the reason is because in the last 5 to 7 years, Indian courts have just become so pro arbitration. Since the time you had Balco, it took 1 or 2 years for all the Indian courts to align with what the seat concept is, how it is different from venue, what a seat court should be doing. And after that, you've seen an avalanche of judgments which have just said that, listen, as long as it's a foreign seated award, you have to satisfy the New York Convention criteria, which is again captured in the Indian Arbitration Act, for an award to be refused. And if it doesn't come within those strict parameters, you cannot just go and revisit the merits and refuse recognition. That's not happening. And the same applies for setting aside. So in that sense, Indian courts are extremely, extremely accommodative towards arbitration. And the parties have realized it, which brings me to the second criteria, which is ad hoc versus institutional. And I think a lot of commercial contracts between two private parties are going for institutional, especially the cross-border transaction. I think for cross-border transactions, I think it's a no-brainer that some institution would be adopted. Where you end up seeing ad hoc is with contracts with government. I think there the government is still insisting on ad hoc arbitration. Certain governments, for example, the Maharashtra government at one point of time started putting MCIA as a default clause for all government contracts above a certain value. The same thing is happening with Hyderabad, with the Hyderabad International Arbitration Center coming along. And I think this trend will also catch on. So I think over a period of time, you will see a lot of these ad hoc clauses getting converted into institutional clauses, and India moving in the direction of China, in which you will have 20 institutions operating in India and all of them having enough cases to administer, because that's what institutional arbitration is going to be like.
And I've also seen that Indian courts have been referring arbitrations to arbitral institutions nowadays. So that is also another positive shift towards institutional arbitration.
Yeah, yeah, spot on.
So now, when we talk about arbitrations between India and US parties, there are it is bound to be in this way that cultural issues will arise. So, what are the different cultural issues? And US style of procedures are much different from the Indian ones. So, are Indian lawyers comfortable with such procedures, US style procedures, and everything? And what all issues that you have faced in your experience?
Well, actually, I'm facing one issue right now with one case that I'm dealing with, in which it's against a party in Texas. But frankly, I'll start with the point of similarity. One point of similarity is that the parties from both US and India are extremely aggressive. So that, in that sense, they will approach a case, they will end up adopting guerrilla tactics if they have to. They will be they will use ultra aggressive language in their pleadings and also in the communication between lawyers, etc. So in that sense, they're quite similar. Where the difference arises is exactly the kind of procedures which are used in arbitration. I think a lot of US lawyers don't realize what international arbitration go to procedures are like. They still want depositions, they still want broad based discovery. I'm currently trying to negotiate a neutral arbitration clause because there was a pathological element involved in it. Because of which the US lawyers are telling me that let's put depositions, let's put discovery, etc. And I have a different mindset, but at some point we'll reach a middle point. But the point is that they still don't appreciate how international arbitration works, and that's why those cultural differences will remain. In that sense, US is actually an island in its own. It's not in sync with jurisdictions like UK, France, Geneva. So it's operating in a different way. Let me just put it there.
I'll slyly here wear my hat of promoting institution and mention Rule 2610, Rule 26 sub 10. It is mentioned in AAA-ICDR rule that discovery procedures, US discovery procedures, are not the advised way to go, and it should not be followed. So, a little promotion from my end. Now, coming to interim reliefs, we have seen quite a spur in the market recently, in some disputes recently. And I have also seen, and this is my personal view, that Indian parties are reluctant in going to emergency arbitration for their interim reliefs, and they want to go for to Indian courts to get an interim relief. Is that correct?
I think I'm going to borrow an expression from Karthik, which is horses for courses. I think it honestly is. Emergency arbitration and interim relief from courts, they go hand in hand, and you have to be very clear what you're opting for. Even if you opt for emergency arbitration as the law stands in India today, there can be possibility that you can go to an Indian court, provided you satisfy the Indian court that an emergency arbitration is not going to be effective. Also, emergency arbitration awards for which are those seated in India are enforceable because of a recent judgment of Amazon. But when it comes to foreign seated emergency arbitration awards, they are still not enforceable. So, in that sense, going to an Indian court can actually be the only resort because you will not get effective relief. Even if you get a relief from emergency arbitration, which is seated outside India, you cannot directly enforce it in India as the jurisprudence stands. I think this is going to evolve. But why I say horses for courses is because for certain situations, emergency arbitration makes sense. You will have an experienced arbitrator who is more familiar with these kind of issues, who will end up giving an award on it, right? You don't have any redress, you don't have an appeal from an emergency award. You actually end up going to the tribunal when it's constituted, or if it's not constituted, then to the same emergency arbitrator if there is a change in circumstances, and the likelihood is that he will not change his opinion. So there is a sense of finality. But if you get a Section 9 order, you can actually appeal it in Indian courts. And Section 9, for those people who are not familiar, is a provision under the Indian Arbitration Act which allows you to seek interim relief before an Indian court. And in certain circumstances, Section 9 order is actually much more effective than an emergency arbitrator. While you will take 14 days to get an emergency arbitrator's award, a Section 9 ad interim relief can be given on the same day or in 2 days. And the entire hearing itself can get concluded in a month. but you will actually have a relief within 2 days. So you really have to see what you're getting. And for things like confidentiality, right? Like, why would you go to a court? Because a court proceeding in India is all public. So, whereas an arbitrator proceeding is actually all confidential, and that is the right place to preserve confidentiality. So, it's all horses for courses. You have to see what kind of a situation it is. I definitely see in the next few years India coming close to, say, a UK jurisprudence of Gerard Metals, in which emergency arbitrator proceedings would be the primary go to option, and courts will not interfere unless and until the party can exhibit to the court that the emergency arbitrator proceedings will make it redundant. You can't wait for 14 days. You have to have the relief today. So that is the only reason I see the jurisprudence moving towards, in which you can go before a court and not an emergency arbiter. But we are still some time away, and you still have both the options.
So you have already answered my next question, which is enforcement still a concern in India? You've mentioned that courts are moving towards, are taking pro arbitration approach, and the number of actually uh, the awards are not being set aside and they are being enforced in India, and courts are very proactive in doing that these days. So I would not bother you with that question again unless you want to expand on it.
I'm good. I think I've said it all. I think one thing maybe I want to say is that they are being so deferred to arbitration. Like, even if there is an arbitral award against third parties, there are certain situations in which the courts are willing to enforce against third parties. So I think there's a clear expansion of jurisprudence. The Indian courts are borrowing a lot from foreign authors, from foreign cases. They're looking at jurisprudence around the world, and they're trying to apply it to Indian circumstances. So I think they're being very pro arbitration.
Thank you very much. To wrap up the session today, I would now invite the panelists to give suggestions on how an arbitral institution can ease the dispute resolution process for the US and Indian entities, and to make it more accessible to these parties to resolve their disputes in a quick manner. And anyone can take the lead on this question. Karthik, would you like to expand on this?
I take a few shots. I think just not only an arbitral institution, but just ease of doing business in US and India. Where you guys can do some policy, where the arbitral institution can do some policy advocacy, and obviously represent stakeholders, and obviously even for a more streamlined arbitration process. I think one would be perhaps documentation requirements. What can you submit? Does everything have to be apostille? Does everything how does it work? If you're setting up a business in India, or you're setting up any kind of claims, or does everything how do you streamline a document submission process? If the document, if it's Indian law document, if it's not validly executed, etc., it's not being sought to be enforced in India. Maybe we can do away with the stamping requirements. Maybe we can do away with certain apostillization requirements, etc. The same thing comes down to doing ease of business. I mean, maybe much more simplified KYC. That if you have a US passport, or if you have a US social security number, perhaps that should be good enough for opening a bank account in India, or for becoming a director in India, versus just going through the whole process of apostilling, going to the Indian embassy to get your documents consularized in the US and then showing them here. So maybe some kind of simplified, unified KYC as well. I think just more in terms of process. People need to think a little bit more about that. Not just, like I said, not just for ease of doing arbitration, but also for ease of doing business. And I think some other rules as well, around policy making, which can sort of help in this whole US India corridor. We have a really nice legislation in India came out last year, which says if you want to do a fast track merger between a parent company and a wholly owned subsidiary, you can do it without NCLT approval, so long as your the entity which is being merged, there's a parent and 100% wholly owned subsidiary relationship. Now I see a lot of US businesses in India. They've got not one, two, three, four. They've got a lot of subsidiaries not doing different things for legacy reasons. Some subsidiary must have been set up back in the day. Some subsidiary must have got acquired as part of a larger global acquisition they've done. So they all want to sort of just streamline their compliance. Have fewer entities operating in India. I think for those kind of entities, maybe the rule making, just taking a leaf out of this fast track merger when you're a parent in a wholly owned subsidiary, just taking a precedent from there. Maybe things to consider from a policy advocacy perspective is a lot of the if you're 100% sub, maybe a lot of the other requirements, let's say in terms of having a mandatory auditor, in terms of, let's say, a certain board requirements of annual board meetings, etc., minimum number of board meetings, some requirements under FEMA that look, you can't have certain amount of shareholder loans given by a foreigner to an Indian. Maybe I think, there's case to argue that, look, those kind of relationships where it's 100% sub in India, there should be some exemption. The compliance in terms of governance, etc., can be a bit more light touch than what it is right now.
Thank you very much. From a resolution practitioner's perspective, would you have any suggestions? Okay.
I think, Asta, one thing which is increasing traction these days amongst a lot of users is mediation. I think for an arbitral institution like yours to promote mediation in conjunction with arbitration, I think is the trend that I'm seeing. And I think it's going to become more and more relevant because there are certain cases, and I'm dealing with a couple of them right now, in which the amounts are not that high and the parties do see the need of a settlement. So I think coming up with clauses, that med-up clause or ARP med-up, I think all of that is going to be more and more relevant for in-house people.
KK, you are giving me more opportunities to promote promote ourselves. So just quickly and not diving deep into it, AAA ICDR's rules, we have presumptive mediation now with the option to opt out. But unless the parties opt out, they have to go for mediation. And what's unique about our rules is that when parties are mediating, at any point, any stage in arbitration, the arbitration doesn't stop. The mediation and arbitration, they go parallelly. So in case there is a settlement in mediation, of course, we have the resolution. But in case there isn't any settlement, the arbitration is parallelly going on and there's no wastage of time. So this is a very time-effective method that we have recently come up with in our recent amendments of our rules. We are yet to see the results because it's been very short. But yes, so
That's good.
we are working on your suggestion.
That's good. That's good.
And now we have way less time left. In fact, we have consumed all the time. Very quickly, just one question I will take from the audience. I think, KK, this is something for you. Indian parties transacting with foreign entities are usually agreeable towards choosing English law as the law applicable to the contract. Are US parties similarly agreeable to choosing English law? Are US counsel parties generally comfortable with English law?
I think their first preference is always to go for a US law. But generally, when it comes to the dispute resolution clause, it's a little bit of a horse trading. Some party ends up giving up the seat, the other party ends up giving up the governing law. And I think somewhere, if the Indian party is getting the seat, the US party will call the governing law. If the US party wants New York seat, then the Indian party will call the governing law. And I think somewhere you enter into a settlement. But I think after US law, if there is, like New York law or any other law of the US states, if there is any law which the US parties are comfortable with, it's actually English law. So that's the next best choice for them.
Unless we have any further questions from the audience.
I think there were a couple of them getting screened. You want to ask one of them? I think they'll feel a bit left out.
I have probably for Renuka and Karthik to answer. Do you sense any hesitation from US entities in making large investments in India, given India's approach to investment treaty arbitration?
No, I can take that first. I don't see any such hesitation, and I think, frankly, if you look at India's track records and what the courts have done with, on investment disputes, or even, where it comes to disputes with the government, I think it's been very clear that it's the rule of law. I think it's just reaffirmed the fact that, the judiciary is independent from the executive, and that, sort of makes India more attractive. Something like a Vodafone, with the Supreme Court eventually found in favor of Vodafone. Something like a Keynes, where there were extensive enforcement proceedings, but the government realized that look, there's no point just litigating this for the heck of it. Let's reach a settlement. Something like NTT Docomo, where look, after multiple rounds of arbitration and then obviously litigation, there was no attempt to stop the indemnity payment to the claimant there. So I just think, frankly, if you see that judicial trend, I just think it's very encouraging for a foreign investor that look, there is, you will get an impartial hearing. There is no bias against a foreigner. I just think, it makes it, and the fact that the legislator and the executive and the judiciary, all three different branches, and it's just been tested through these, high value situations. I personally think it just inspires confidence to invest rather than to stay away. Uh, Renuka, to you.
I totally agree with that, Karthik. I think there is more, the judicial system is more understanding as to what is the problem, and there is a deep dive analysis also that the judicial system is undertaking, and they're very welcoming to understand the problem statement in detail before even passing any order, and there is no haste in passing any order. That there is a clear understanding, uh, including IP related litigations I've seen. So, yes.
Thank you, Renuka, and thank you, Karthik. With this, we conclude our session for today. Oh, we have another question which is interesting, and I think we can take it just quickly if you can answer this. How is joinder of non signatory parties to an arbitration agreement viewed by Indian businesses? Could you please, can we see the question again, please? How is joinder of non-signatory parties to an arbitration agreement viewed by Indian businesses? Is arbitral joinder subject to collateral attacks in Indian courts? KK, would you like to take
I'm happy to take it on. I think the short answer is no. It's not subject to challenge. I mean, it can be challenged in Indian courts. Whether it will be successful, I think the probability is quite less. I think Indian courts are very differential when it comes to arbitral tribunals' decision on joinder and consolidation. The moment they have seen the evidence and given a reasoned decision to come to joinder or consolidation, the Indian courts will not interfere.
Thank you. With this, we conclude our session. Thank you to all the speakers for joining us today. A big shout out to Michael and Pam for making this happen. Now, with further ado, I invite everyone to join us for some drinks. Thank you. Signing off.
Thanks, Asta.